Hello, everybody. Oh. She was waiting. She knew. I swear, somebody told her. Hello, C-Rex. Hello, Nana Laura. Hello, Uncle Charlie. How you doing? It is, but people aren't used to me being on live during the day. I can't blame them. They'll get here. They'll see it eventually. In the meantime, real quick, we've got treats to disperse. You want your busy bone? That'll keep you busy for sure. And just think, you guys get to see the cases from the start. You know, you don't have to play catch up. Isn't that the best part? You get to stay current in the chat. I know that's my favorite part, is the chat. Hello, Brian Boggs. Yay, I'm so happy to see you. See, I told you they'd come when they saw me. All right, we got some good stuff for this afternoon. For Nana Laura, I can say afternoon. It's evening for me. Well, sort of. It's nearly 6 o'clock. I heard a meow. It is still day. It is still daylight. It's daylight out. See? You can see the sunlight coming through. Hello, Shane. Good to see you. Yep, it's all about how you word it. Day shift crew, yay! I'm happy you made it too. I am still hoping to come on tonight. I've got it started over there. Like the editing process it's going. So I'm hoping I get enough to run tonight. Last night I was trying to edit and I fell asleep and I woke up at 11:47 because C-Rex texted me. And I sent her a picture of my face at that moment. And it wasn't pretty. It was not. No. She's like, baby girl, you need sleep. But of course, then I was awake. I had nothing to run. I had no cases because I fell asleep editing. Yeah. But, so I figured I would come on. It's a process. Yes, it's a process. I can't wait until I see my sleep apnea doctor. I really can't. I am actually looking forward to it. Hello, Salty Buddha Love. Good to see you, honey. It is. It's not my fault y'all are so dang funny. Yeah. All right, guys. Let's get it started.
Okay, the court is on the record in State of Ohio versus Lucas Vickery, 24 CRB 348. City of Conneaut versus Lucas Vickery, 24 CRB 268, 24 CRB 267, 24 CRB 251, 24 CRB 213. All of these cases are set for a preliminary revocation hearing today. Probation violation complaints were filed against Mr. Vickery in all of these cases. On January 8th of 2025, warrants were issued for his arrest, And Mr. Vickery was arrested on those outstanding warrants on February 26, 2025. He is appearing at this hearing by way of video from the Conneaut City Jail. Also present is probation officer Sean Benoit, who is appearing on video. He's in the courtroom. Mr. Vickery, several probation violation complaints. They're all the same complaint, but they've been filed in each of these cases. Have you received copies of those complaints?
Yes, sir.
Okay, I'm going to read you your rights. So please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the complaints filed against you. You also have a right to know the potential penalties that could be imposed. In 24 CRB 348, this is where you were recently convicted on December 10th of 2024 of receiving stolen property. The probation violation complaint, and the complaints all allege that you failed to maintain contact with adult probation, failed to comply with recommended treatment through community counseling center as ordered. But anyways, if you're convicted of violating your probation in this case, I could impose up to 165 days in jail. I could extend your probation from what was originally 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. Do you understand the maximum penalties you face if convicted of violating your probation in that case?
Yes.
The next case, 24 CRB 268, you've been convicted of 2 counts of theft. If you're found to have violated your probation in that case, and those sentences were ordered to run consecutive, I could impose up to 342 days of jail, 171 days on each of those counts of theft, so a total of 342 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So when I say 342 days, that would be in addition to the 165 days that you face on the previous case, receiving stolen property case. So in total, I could sentence you to up to 507 days in jail if violating your probation in both of those cases. So do you understand that?
Yes, sir.
In 24 CRB 267, you were also convicted of theft, another count of theft. If you're found to have violated your probation in that case, I could impose up to 171 days. That would, even though I originally ordered those consecutive, unfortunately for me, I cannot impose more than 540 days of jail. So that would have to be concurrent to any sentence. So that would run at the same time of the 507 days that I've indicated, the maximum time you could serve. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So do you understand the consequences you face in that case?
Yes, sir.
In 24 CRB 251, you were convicted on August 15th of 2024 of criminal trespass. If you're found to have violated your community control in that case, I could impose up to 29 days in jail to run at the same time or concurrent with the other jail sentences. I could extend your 1 year of supervised probation from 1 year up to 5 years, and or I could impose more restrictive community control sanctions. You understand the maximum potential consequences you face on that case?
Yes, sir.
Finally, in 24 CRB 213, you were convicted of littering, a first-degree misdemeanor, on September 9th, 2024. If you're found to have violated your probation in that case, I could impose up to 171 days in jail. Again, that would run concurrent or at the same time of your other jail sentences. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So do you understand the maximum consequences you face on that case?
Yes, sir.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a final revocation hearing. That's another hearing. At that final revocation hearing, you would have a right to cross-examine witnesses and confront evidence presented against you. You would have a right to testify or not to testify without any negative connotation. You would have a right to subpoena witnesses to testify on your behalf. You would have a right to be proven guilty by a preponderance of the evidence. All of those are hearing rights you would have at that final revocation hearing. You also have a right to an attorney, to have an attorney represent and advise you in this case. And because you are facing a possible jail consequence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply, because I believe in all of these cases you were never represented by counsel of the public defender's office in particular. You also have a right to a continuance of this preliminary revocation hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of violating the terms of your probation in any of these cases, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to any of these probation violation complaints, I will set your case or cases for further proceedings after today. I'll set it for a final revocation hearing, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, and today you have the right to a reasonable bond. So with respect to each of these probation complaints, Mr. Vickery, you have two plea options. You can either plead guilty or not guilty. If you plead guilty, that is a complete admission by you to the complaint filed. If you plead guilty or completely admit to the complaint, the court will find you guilty and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the complaint filed, and as I said earlier, if you plead not guilty, I'll set your case or cases for a final revocation hearing in the near future, and I'll set a bond. Mr. Vickery, do you have any questions whatsoever regarding the rights or the plea options I've just explained to you?
No, sir.
Okay, we're going to start with the probation violation complaint. They were all filed on January 8th, 2025. With respect to the first case, this is the receiving stolen property case in 24 CRB 348. How do you plead to the probation violation complaint in that case?
Guilty.
In 24 CRB 268, this is where you've been convicted of 2 counts of theft on September 9th, 2024. How do you plead to the probation violation complaints in those cases, or in the complaint in that case?
Guilty.
To the probation violation complaint filed against you in 24 CRB 267, this is where you were convicted of 1 count of theft on September 9th, 2024. How do you plead to the probation violation complaint in that case?
Guilty.
to the probation violation complaint filed against you in 24 CRB 251, where you were convicted of criminal trespass, a 4th-degree misdemeanor on August 15, 2024. How do you plead to the complaint filed against you in that case?
Guilty.
Finally, with respect to 24 CRB 213, where you were convicted of littering on September 9, 2024, that is a 1st-degree misdemeanor. How do you plead to the probation violation complaint filed against you in that case?
Guilty.
Do you understand, Mr. Vickery, by pleading guilty to these complaints, that you are waiving your right to a preliminary and final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you? You'd be waiving your right to testify as well as not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to be proven guilty beyond a reasonable or by a preponderance of the evidence. All of those are hearing rights you'd be waiving by pleading guilty to these complaints. Are you sure you want to do that today?
Yes, sir.
You are also, by pleading guilty, waiving your right to an attorney. You do not have an attorney that is representing you or advising you at the current time. By pleading guilty, you would be waiving your right to an attorney. Is that what you want to do?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, sir.
Are you currently on probation, parole, community control, or post-release control with any other court?
No, sir.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to these complaints?
No, sir.
And are you thinking clearly and you understand everything that's happening?
Yes, sir.
Okay, I'm going to ask the corrections officer to provide you with 5 of the separate Form 5s. So one for each of the cases. They're Form 5. For the record, Mr. Vickery, do you read and write English?
Yes.
Now he's going to give you 5 of these forms, one for each of the cases. The form says all the same thing. Basically says, I understand that I have a right to a preliminary final revocation hearing. At any hearing, I have the right to confront witnesses against me, to cross-examine witnesses, and to require the case be proven by a preponderance of the evidence. At my hearing, I could testify on my own behalf, but that I could not be compelled to do so, and that I could have witnesses testify on my behalf, and have a compulsory process for obtaining the presence of witnesses, that I have a right to an attorney and a right to a postponement to secure the services of an attorney, and that I am without funds to secure the service of an attorney, and the court finds this to be the fact, I have a right to have a court appoint an attorney to represent me without charge. I hereby waive these rights and submit the matter to the court. If you find those documents, all the same document, acceptable, you can sign and date at the bottom of each of those 5 documents.
They've all been signed, sir.
You know, it sounds like the defendant is complying really well and everything's going smoothly. What on earth could go wrong here?
Thank you. Thank you. The court finds that the defendant has executed in open court the 5 separate waiver of hearing rights and probation violation matters. Before I make a finding of guilt, Officer Benoit, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, officer, can you tell us, first off, your name, your position, and the nature of and the basis for these probation violation complaints?
I'm Sean Benoit, City Probation Officer. The basis of the complaints arise from him not maintaining contact with myself in my office through scheduled appointments, and he failed to comply with the treatment recommendations through community counseling. He had assessments complete while he was incarcerated the last time, had appointments scheduled that he failed to maintain, and that was about it, Your Honor.
court finds probable cause exists for the filing of the complaints. I do find Mr. Vickery's pleas of guilty to be knowing, voluntary, and intelligent. As I said, I do accept the guilty pleas, and I will therefore find him guilty of violating his probation in each of these cases. Okay, Mr. Vickery, before I impose sentence, and you do face up to a maximum 507 days in jail, is there anything you would like to say?
No, sir.
Seriously?
Yes.
You don't have anything? You don't have anything to say, Mr. Vickery?
No, not at the moment.
I mean, this has been your mantra ever since we started seeing you, in the summer of last year. I mean, you just come into court, you admit to the complaints, you don't want an attorney, you just want me to sentence you. Do you want me to send you to jail for 507 days? Is that what you want?
No, sir.
Well, then tell me why. Tell me why I shouldn't send you to jail for 507 days. Speak up. Defend yourself. Say something. Help me to know what is going on in that head of yours.
Sir, I would like to become a productive member of the community. I've had trouble finding employment, and I've had trouble finding housing. And I had just recently obtained a phone to make contact with Mr. Benoit.
What
I understand
was that last?
What was that? Made contact with him.
What was that last part? I didn't hear that. I'm sorry.
I had just obtained a phone to contact Mr. Benoit.
You mean the probation officer, Mr. Benoit?
Yes.
You mean to tell me you never knew how to reach him before just recently?
Not other than to walk into the courthouse.
Well, that's a lie. You want to stick by that statement? The last time you were in jail was not too long ago, and I know Mr. Benoit met with you and he gave you his contact information. Is that correct, officer?
You
Of course.
were in car with the next woman.
Yeah. You know where his office is. You know where the court is, right?
Yes, sir.
You ever make any attempt to come up here and to have communications with him, or do you wait for us to reach out to you?
No, I did not make any contact with him.
Okay. Did you ever follow up or follow through with anything that was required of you at the community counseling center after you were assessed in the jail the last time?
No, sir.
Why not?
No answer, sir.
You want to become a productive member of society, yet you don't follow through with anything. What's going on with you, Mr. Vickery? We've had this conversation before. You don't have much of a criminal history other than what's happened in the last year. So what's going on? Why all of a sudden are you doing what you're doing and you don't seem to care?
I just don't know what to say, Robert.
Okay, Officer Benoit, any positions?
No, Your Honor, I do believe that he does have a desire to change, and given opportunities, I would hope that he would take those opportunities if he was presented with one.
Okay, Mr. Vickery, I want to hear it from you. I want to hear it from you. And I shouldn't be begging you to tell me that you want help. You understand that?
Yes.
I mean, if you really wanted help, Mr. Vickery, you would be on your hands and knees asking me for help. But instead, you just say, well, no, I don't really have anything to say. So I'm giving you this opportunity, Mr. Vickery, to tell me what you would like the court to do.
I would like help, sir.
What kind of help, Mr. Vickery?
Help with rehab, help with employment, help with housing.
And we've offered you help perhaps not as intensive as what help we could provide you, but we have provided help for you in the past. Why haven't you, why should I say, or why should I be thinking that today is any different than the past? Probation officer is there to assist you, to insist, because I've ordered you in the past to obtain and maintain employment. I've ordered you in the past to get an assessment and to follow through with any recommended course of treatment. The probation officer is there to assist, to help you improve your life. So help me understand why now is different than the past times when we've offered you that assistance.
He wants to just be a bump on a log. That's it. He sits there and watches life go by. He doesn't make things happen. Unfortunately, that's not how you get yourself clean and sober. You have to take initiative. The judge is just trying to get him to take some kind of initiative. Even if it's as simple as declaring what resources you need, because they're not just going to fall into your lap.
Your Honor, I don't want to spend any more time in jail. I would love to spend time with my kids, and I would love to just get back to normal. I apologize for not following through with the assessment and everything before. I will do this time.
Okay. So before this hearing, I had Officer Benoit and our bailiff meet with you. So Officer Benoit, did you happen to talk to Mr. Vickery about renewal court?
Yes, Your Honor, I did talk to Mr. Vickery about renewal court. I let him know about the program, the intensity of the program, what is expected of him, what it provides him. Mr. Vickery did accept and fill out an application for that specialty document, Your Honor.
Okay. Mr. Vickery, renewal court is an intensive supervision program. As Officer Benoit, I'm sure, has explained to you, it's intense. But if you really want to change your life, and based on what Officer Benoit has indicated, you've actually signed an application to be part of that program, there's a lot going to be required of you. Are you ready for that intensity, that very intense supervision that will come with that program to help you change your life?
Yes, sir.
You do have that application?
Yes, Your Honor.
Okay. Okay, here's what I'm going to do. He was arrested on February 26th, right?
Yes, Your Honor.
So he's entitled to 2 days jail credit. February 26th to today's date, February 28th. In 24 CRB 348, this is the receiving stolen property case. I'm imposing a jail sentence of 15 actual days in jail. So 180 days, total sentence 150 days, suspended. I will give him 2 days jail credit, which means he has to serve for an additional 13 days. That will give, I believe, the agencies time to conduct another assessment on him, because I'm sure they're going to need to assess him again, and for all the screenings to be done for renewal court purposes. I'm going to extend his probation for 1 year. I'm ordering him to obtain a comprehensive diagnostic assessment with the Lake Area Recovery Center and Community Counseling Center, and to comply with any recommended course of treatment. He's to remain drug and alcohol free, and all the other conditions of his probation that are already in place will continue. I will order him to successfully participate in and complete renewal court if he's determined to be eligible. In case number 24 CRB 268, and I'll start with 268A, that's the first conviction of theft. I'll give him, this is consecutive, so I'm going to suspend all 171 days in jail in subcase A as well as subcase B, so there won't be any actual jail time. I'm extending his probation for 1 year. Comprehensive diagnostic assessment at Lark and Community Counseling Center, successfully participate in and complete renewal court if determined eligible. And you know, I'm just gonna stop right here because I'm gonna keep going, but I want to just say something, Mr. Vickery. Part of that recommendation may be that you have to go into residential treatment, meaning that you're going to go to live somewhere to help assist you with your treatment. I want to make sure that I'm not the experts. They're the ones who are going to determine whether you qualify for residential treatment or not. But I want to make sure, Mr. Vickery, that you're on board with that.
Yes, sir.
Okay. 24 CRB 267. This is the conviction of theft. Again, 171 days will continue to be suspended. I'm extending his probation 2 years or 1 year for a total of 3 years. And if I misspoke, I want to make sure all of these probation will be extended for 1 year. Lake Area Recovery Center and Community Counseling Center assessment, comprehensive diagnostic assessment, successfully participate in and complete renewal court if determined eligible. Now, all three of those sentences in 24 CRB 348, 24 CRB 268, and 24 CRB 267 are consecutive. And that's the most I can sentence him to. The other cases, 24 CRB 251, criminal trespass, I'm going to order the same things, but I'm suspending 29 days, but that sentence is concurrent. I'm extending his probation from 1 year up to, from originally 1 year up to 2 years, so I'm extending it to 1 year. All the same conditions, comprehensive diagnostic assessment at Lark and Community Counseling Center, successfully participate in complete renewal court if deemed eligible. The same applies to littering in 24 CRB 213. 171 days will be suspended concurrent to all other sentences, extending his probation 1 year. Comprehensive diagnostic assessment at Lake Area Recovery Center and Community Counseling Center, and successfully participate in and complete renewal court if deemed eligible. So you're going to sit there for a couple weeks, Mr. Vickery, and we're going to get you assessed while you're in jail. If by chance we receive assessments and completed screenings before your 13 days, the balance of your 13 days of sentence happens, I may release you early, and especially if it's directly into a residential treatment program. So we're going to try to get those assessments scheduled as soon as possible. And then if by chance, Mr. Vickery, you are found to be eligible for renewal court, I will conduct one more hearing to welcome you into that program. And so right now it's up in the air. We don't know whether you're going to participate in or not. It all depends on those screenings. So do you understand all of that, Mr. Vickery?
Yes, sir.
You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided you necessary to file an appeal without cost. And you have a right to have a notice of appeal timely filed on your behalf. Mr. Vickery, do you have any questions whatsoever?
No, sir.
Officer Benoit, anything?
No, Your Honor.
Okay, this matter is concluded. Thank you.
Okay, guys, get ready to actually maybe kind of fall in love with the defendant a little bit. He's an adorable old man.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus George Allen Likes. It is case number 2024 CR 194. Jill Gillette appears as Greenwood County Attorney, Gary House as Defense Counsel of Record. George Allen Likes is not present on the meeting as he was previously ordered to be. Mr. House, do you have an explanation as to why your client isn't on this meeting for sentencing in its case?
Yes, Your Honor. First of all, he understood that it was to be an in-person hearing, and I know he's been in contact with Tony Bauer on a regular basis. I've had contact with him yesterday and on Friday and about every day this week. He's in a motel in Salina. His sister lives in that area. He had counted on his brother-in-law to bring him down, but that fell through last night because the brother-in-law is sick. And I told him he's available by phone if necessary. He says he can't do Zoom. He doesn't know how to do it. And of course, he's there. He's got the monitor and he's got the alcohol monitor also. I don't think there's been any problems with that. So I would respectfully request a continuance, and I apologize for it. But that's the situation.
Well, even if he believed that it was an in-person proceeding, he really should be at the Greenwood County Courthouse in Eureka participating from a sheriff's monitored location from there. So we'd still be able to go forward with sentencing.
Yes.
It's incumbent on a defendant to make sure that he is in court. And I'm not going to do a sentencing on a felony case, especially one with the potential implications that this one has, without having him fully on the meeting, both by video and audio. While I would have certainly been amenable to conducting the sentencing by Zoom, he's not here. I can't conduct the sentencing. So, Ms. Gillette, you've heard Mr. House's request. What is your position?
This is a hard one, Judge, because I know Mr. Likes can't run Zoom by himself. And I don't know why he didn't have family to be able to bring him or call his bondsman, because if you can't find a ride, your bondsman's your first call. I do know he's on GPS, and if he was somewhere he wasn't supposed to be, they'd let me know. I think I would be okay with a very short continuance to get his sentencing done. You know, when he's in custody, we know where he's at and he's able to Zoom from the jail. But at the same time, I know he's on GPS and Scram and that he's still at Salina. The GPS gives me a little bit of reprieve to know he's not out there drinking and driving currently. So I would say a very short continuance to get the sentencing done. I don't know if we can get a special setting. If he can't get his brother-in-law to drive him here for court, he needs to contact his bondsman right away, because they are responsible for making sure someone's in court.
I think Mr. Florio is his bondsman, Jill.
Counsel, if I were to try to schedule this next Friday, perhaps my Butler jury trials will be all completed by then. Your availability on, say, Friday morning of next week?
Judge, I am available because that is a traffic day for Mr. Dean with Judge Webster.
All right, Mr. House?
Your Honor, I do have court occasionally in Chautauqua County, which is right here in Sedan, and I'd certainly be available whatever time you said it.
Mandy, what time do you suggest? Okay. Well, let's set it a little later. I don't know whether he's going to try to come down and participate from the courthouse or not. Let's give him adequate time to do it. Is 11 available?
Yes, it is, Judge.
Right. I want to suggest 11 o'clock a.m. next Friday, which would be February the 28th, I believe.
Judge, we did have that marked off for some reason.
Okay. Well, then.
The whole day, actually.
Excuse me?
The whole day we marked off for some reason.
Other than for the jury trials that we have set next week?
Yeah, if it's fine with you, it's fine with me.
Okay. Let's stick with the 11 o'clock a.m. then, next Friday, February the 28th. I will expect Mr. Likes to be at the Greenwood County Courthouse in Eureka, Kansas, and participate from there. I never have any Zoom issues when people appear at the courthouse.
Yes, Your Honor. And I will instruct him to do that, and I'll also tell Mr. Ron Florio, who is his bondsman, the situation, to make sure that he's got transportation.
I don't like to do this. I expect a criminal defendant to be in court on time as scheduled for a felony sentencing. I do note the state's position, rather magnanimous under the circumstances, I might say. In light of that, the court will grant this continuance requested by the defense one time to February 28th at 11 o'clock a.m. I regret that the other officers that joined the meeting today have been inconvenienced by this continuance. But we'll address the case again February 28th, 11 o'clock a.m. by Zoom, using the same Zoom numbers as we utilized today. Mr. House, is there anything else we need to address at this time?
No, Your Honor.
Ms. Gillette?
Nothing else from the state. Thank
Very well.
you, Your
Then the-
Honor.
Excuse me? All right. If there's nothing further, then the likes matter will currently be in.
To get the internet password for that iPad for upstairs before
Okay.
we all get in. Sorry.
Okay, that's fine. I appreciate your efforts. This is State of Kansas versus George Allen Likes. It's Greenwood County case number 2024 CR 194. Mr. Likes appears from a Zoom location at the Greenwood County Courthouse in Eureka. Jill Gillette appears as Greenwood County Attorney. Gary House is Defense Counsel, separately from his client by Zoom. This matter comes before the court at this time for sentencing. Court has received a pre-sentence investigation report compiled by Tony Bauer, pre-sentence investigator. And I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in the report?
No, Your Honor.
Any objection by the defense, Mr. Likes?
No, Your Honor. We're showing this as a criminal history I, which is the best criminal history he could have.
All right. All right. Thank you for answering on behalf of your client, Mr. House. There's no objection to the criminal history, and the court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed accordingly. I will also note for the record in this case that the plea in this case was no contest. It was to counts 1 and 3, and it was entered on December 26th of 2024. I'll also note for the record that there was a pre-sentence substance abuse assessment submitted to the court electronically just this morning. Ms. Gillette, I did want to confirm that you have received it.
Yes, Your Honor.
All right, very well. So, Ms. Gillette, is there any legal reason why sentence should not be pronounced in the Likes case this morning?
None from the state.
Mr. House, are you aware of any such legal reason?
No, Your Honor.
Mr. Likes, are you aware of a legal reason or any other good reason why the court shouldn't go further with your sentencing today?
No, sir. I'd like to get it behind me instead of in front of me.
Yes, sir. Court will proceed further then. I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
The state does not, Your Honor.
Does the defense, Mr. House?
No departure motions, Your Honor.
Is there a victim or members of a victim's family present who desires to address the court in relation to the like sentencing? Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Likes, beginning with Jill Gillette on behalf of the state.
Your Honor, on this case, it has a partner case in Elk County. That case is Elk County 2024 TR 140. It is a driving while suspended TOC and no tag. Its date is October 17th of 2024 is it when he accrued that case. This case is October 30th, 2024, just so you know, we're dealing with those two cases for Mr. Likes. There's two cases listed, but the 112 was dismissed pursuant to the plea in 140. Now, on Mr. Likes's case, this is a DUI fourth. It It scores out as a level 6 felony. It is recommended 17 to 19 months. I am going to recommend the number of 18 months as his underlying sentence. Mr. Likes is supposed to be attending some treatment. I hope that it all works for him. I know he did some inpatient treatment. He may have up to 15% good time credit. It is presumptive probation for 24 months. And should he serve any of his underlying 24 months post-release supervision duration. He does have jail credit for 92 days, and those are set out on the PSI. We'd ask the court award those. On count 3, the DUI provisions of ignition, no ignition interlock. From his prior DUI, he has not completed the ignition interlock portion, is a Class A non-person misdemeanor. It does carry up to 12 months in the county jail. I would ask that the court order 12 months. I do not have an objection to it being count 1, so that count 1 would be the controlling sentence. And for conditions of probation recommendations, he has scored out for community corrections, and I would request that he be placed on community corrections, both because of his history, his very high score on the LSCMI and 8-1567. He has had an evaluation. I ask that he follow all the recommendations set out in the evaluation. Not to possess or consume alcohol or illegal drugs. Make it very clear to him, no alcohol or any other drugs except for prescribed by his doctors. Be subject to breath, blood, and urinalysis testing. Has to notify them in any changes. I know that he is retired, so I believe that he does not need to have full-time employment, but abide by all of his retirement things that he's doing as his income. He will need to submit his DNA to the KBI. I am not sure whether or not his prior DUI was submitted as a felony. And there would be a $200 fee for that. Curfew as put on by his supervision officer, any travel restrictions per his officer, and not to be in places that serve alcohol as their primary service. If there's a bar and grill that he's in that's primarily a grill, I would understand, but no consumption of alcohol while there. Court cost, felony court cost, DNA database fee, community corrections and correctional supervision fees, they're $120 and $125 respectively. Bids application, his attorney is retained, so there's no bids considerations. $45 booking fee. Now, I wanted to talk to the court about, there is a KBI lab fee. It is $400. This was a blood test for the alcohol and the fine. This being a 4th time DUI has a much higher fine. I believe that it is up to a higher amount, but the minimum of $1,250 may be a little different based on what's going on, but $250 of that fine, Your Honor, may be assessed to the Community Correction Supervision Fund to help with the intensive supervision funds being used to supervise Mr. Likes. The case in Elk County, he was on bond for. They were 13 days apart. Mr. Likes racked up several cases very quickly. So I don't have an objection if the court wants to run them concurrently. He has done inpatient treatment. He's been on scram for the second time throughout the duration of his cases since July through now. And the scram served to help make sure that he was not consuming alcohol. And he will have to have an intoxilizer before he can obtain a driver's license. He'll have to serve out an intoxilizer and keep it in a vehicle. There is also $31.71 for a medical bill for while he was in custody that would need to be reimbursed as restitution to the citizens of Greenwood County through the sheriff's office if the court so orders the reimbursement of the restitution for medical bills. There is a mandatory 30 days to be served. Mr. Likes has spent 80, I think I had 87 days, but 92 days down, sorry. 92 days in custody. That would be more than sufficient to cover the 30 days of confinement that he would be required to do. And I'll leave it up to the court as to whether or not there should be additional time that's the mandatory time, but he has done 92 days.
Just to let a fine is not mandatory on a level 6 felony case, is it?
I thought it was. I'll double check, Your Honor.
All right, you can do that. I'm going to go ahead and address Mr. House and ask for his recommendations regarding an appropriate sentence.
Your Honor, I'll concur with most of the recommendations that the state has made based on our plea agreement. As to count one, the level 6, the standard sentence of 18 months, we concur with. And the probation, of course, is with community corrections for 24 months. With the 92 days jail credit, we're asking that count 3, circumvent the interlock device. Class A misdemeanor be a 12-month sentence to run concurrent with that 18-month sentence on count 1. And I agree with the court. I can't find any specific fine in the new DUI law, since this is a severity level 6 non-person felony. So I'll rely on what the court and the state think that should be. I don't have any problem with the curfew requested, and I don't have any trouble with the various fines, or various court costs, fingerprint fee, KBI lab fee. Mr. Likes will be on probation for 24 months, so he'll have time to make payments on those things. And I'd certainly request that his 30 days required that he serve be taken out of that 92 days that he's already served. So I think as to this case, that would be my recommendations.
All right, and you are indeed retained counsel here. Is that correct, Mr. House?
Yeah, yes, Your Honor.
Very well. Thank you. At this time, the court will address the defendant, George Allen Likes, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Likes?
Well, Judge Ricky, I have learned a lot in that 92 days in the Greenwood County Jail, the error of my ways, and I met a lot of young, well, I was the oldest inmate in there, let's face it, but I met a lot of boys in there that need some sort of help, or they're going to follow this this trail of being incarcerated, it looks to me like forever. There's a young boy in there that's 18 or 19 years old. A Mexican boy, he's a good kid, but he has no direction. And not that it's up to me to counsel those guys, but I felt sorry for some of them because they need help and they're not getting it.
Maybe counseling them wouldn't be a bad gig for you. Got a lot of wisdom to offer. You've been through it a couple of times. You've fallen off the wagon, got back on the wagon, fallen off of it again, got back on it again. Sounds like someone who might be able to teach a youngin' a thing or two.
And I own my own charges. I was guilty without a doubt on each and every one of them. And the time I spent in the Greenwood County Jail was pretty eye-opening, pretty humbling, and made me realize that today is the first day of the rest of my life, and I better get straightened up, or it's not going to be fun. I didn't enjoy being in jail at all, other than meeting those inmates and trying to understand why and how they got there. It was pretty eye-opening and very humbling, and I'm glad to be on the outside now, Your Honor. And if I ever get put in jail again, it'll be for praying too hard or plowing too deep, because I'm not going to break the law in any respect. That's all I have to say. Thank you.
All right. Now, Mr. Likes, there was a period of time that you spent in a sober living facility. Is that correct?
Oh, hello, Heath. No, sir, I didn't go there mainly because I didn't want to. That was in January, and it was cold, and the wind was blowing. There was snow on the ground. That sober living place in El Dorado turned me down anyway, and had they have accepted me, that is on the south side of town near the southwest traffic way. And the closest grocery store is Dillon's, and that's about three-quarters of a mile north. And due to my recent back surgery and my inaptness at walking so far, I didn't know I'd get there and back to the grocery store. So I elected to stay in jail another 30 days of my own accord.
Mr. Likes, do you understand that I have an evaluation before me that suggests that you spend 90 days in a sober living facility?
Yeah, that was from Road to Recovery, right?
I'm not sure who the evaluator was off the top of my head, Mr. Likes.
That's
More
correct.
interested in what it said. But go ahead with your
Sir,
statement.
I didn't hear that.
I said go ahead with your statement.
I haven't been in a sober living house, but I went to AA meetings for about 4 years there in El Dorado with several of those boys that were. And I even loaned one of them $300 so he could get his driver's license back when his time was up. And when his time was up, he got his driver's license back, got some dope, and I haven't seen him since. So I'm not sold on the broad spectrum of a sober living place. Just because you live there doesn't mean you're going to learn anything by osmosis, but you got to want to be sober or clean. And I want to be. I don't want to be in jail. I don't want to be stupid. I want to remember what happened last night and look forward to what's going to happen tomorrow. I think that's pretty much all I have to say, Judge.
All right. Thank you for your statement, Mr. Likes.
Sir?
I said thank you for your statement to the court, Mr. Likes.
Thank you. I can't
Okay.
hardly hear you.
And the evaluation was from road to recovery.
Yes, sir.
All right.
Judge, on the fines, it considers the fines on the schedule of what it could be for a level 6 felony. And section F2 says that the court may waive all but $250 that needs to be remitted to the state treasurer pursuant to Q2, which is the community corrections fee portion. And
All right,
that's,
anything further on that, Mr. House?
No, Your Honor, I would concur with that.
All right. Court will pronounce sentence in the Likes case. Mr. Likes, can you hear me now?
Yes, sir.
The court hereby establishes count 1 as the base sentence in this case for the offense of driving under the influence, third or subsequent offense. I think actually this is a fourth. A severity level 6, non-person, non-drug felony, that the defendant has a criminal history score of I, thus placing him in grid box 6I. Court hereby sentences the defendant to the standard term of 18 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 24 months of post-release supervision. Further, this court imposes a fine of $250, generally in accord with the community corrections portion of a fine. Regarding the additional offense in count 3, driving in violation of an ignition interlock requirement, a Class A non-person misdemeanor, the court will impose 12 months in the Greenwood County Jail and run that time concurrently with the felony time imposed on count 1. So the controlling sentence here is 18 months Department of Corrections custody. Mr. Likes, under prior law, this court was required to impose at least 90 days as a condition of probation. The law has now been changed to make that at least 30 days. I will note that your accrued jail time credit exceeds both 30 and 90. Therefore, this court at this time will find that you have jail time credit to meet the mandatory minimum. And I'll sentence the defendant to community corrections probation starting today, or a probation duration of 24 months. Conditions of that probation will include Mr. Likes not violating the law, reporting to his probation officer as directed. He shall not possess or consume alcohol or illegal drugs while on probation. At his supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing. Perform any community service work pursuant to program requirements. Notify the supervising officer of any changes in employment, residence, telephone number, or email address within 24 hours of any such change taking place. Submit his DNA to the KBI databank and be responsible for the $200 cost of the test unless that DNA sample is already on file and the fee's already been paid. He shall abide by any curfew or travel restrictions imposed by his officer. Avoid disreputable characters and places. Follow standard conditions of probation. Not have in his possession firearms or dangerous weapons. This court, in addition to the fine earlier imposed on count 1, will assess a felony docket fee, felony probation fee, community corrections fee, $400 restitution to the KBI laboratory. Court will assess a $45 booking and fingerprint fee and order Mr. Likes reimburse Greenwood County in the amount of $31.71 for a medical bill. Mr. Likes, I need to set up some sort of monthly payment plan for you. I'm contemplating $100 a month starting with next month. Is that something you can commit to doing?
What's the total fine, Your Honor?
I don't know. I didn't add it up.
Could we do that? So I know what
$100 a month?
Sir?
All right. $100 a month starting in March. You need to make sure the clerk of the Greenwood County District Court receives $100 a month starting with March of 2025 and every subsequent month until your case is paid in full, Mr. Likes. If you can pay it off sooner, great.
Fine, thank you.
But at least $100 a month starting with March.
Yes, sir.
The court is in a quandary regarding the substance abuse evaluation received in this case. It calls for 90 days of sober living residence. Mr. Likes, have you been sober for 90 days?
Oh, yeah. Before I had this little episode, Your Honor, I was sober for 4 years and 7 months. Since March 10th of 22, I believe, or 20 maybe. Yeah, since March 10th of 2020.
I also note the long period of jail incarceration in this case, which I would sure hope means Mr. Likes that at least for that 92 days, the Greenwood County Sheriff wasn't allowing you any alcohol in the jail. I hope that's a fair statement.
I'd say that's a fair statement. He's sitting right here.
Okay. Well, I'm sure Sheriff Samuels would confirm that he doesn't allow his jail inmates to have alcohol. All right. Thank you, Sheriff. I appreciate that reassurance. Court notes that to a certain extent, that's the drying out period that might have been contemplated by the sober living recommendation. Mr. Likes, I'm not going to require that. You need to be involved in some sort of help program. I'm going to let you work with your community corrections officer regarding a proper program for you. It could be AA. It could be a formal treatment aftercare program, but you're going to need to be in some sort of reinforcement of sobriety program during your probationary period. Mr. Likes, I think you know as well as I do that if you violate your probation in this case, you could be looking at a prison sentence.
You told me that earlier, Your Honor, and I took it to heart.
Okay, because for you, even a drinking violation could have very serious consequences. And obviously a DUI means you're going to do your prison time.
It's not going to happen, Your Honor.
Okay. I'm pleased to hear that reassurance as well, Mr. Likes.
I'm pleased to hear it myself.
Okay. Already dealt with the issues of restitution and 92 days of jail time credit. At some point in the future, Mr. Likes, you may have the right to seek expungement of these offenses. Certain statutory limitations do apply. If you have any questions about your expungement rights, you can address those to an attorney, and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have a right to appeal their convictions to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Mr. Likes, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Greenwood County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. All right. I'm looking back at Ms. Gillette. Are there other sentencing related matters that the court still needs to address?
You talking to me?
Are you ordering this concurrent or consecutive to the Elk County case?
Concurrent.
And you ordered the counts concurrent with each other?
I did.
Okay.
Mr. House, anything further at this time that you're aware of?
Not on this case, Your Honor.
Any questions from the community corrections officer who's on this meeting?
No, Judge. Thank you.
Okay. Do you happen to be in Eureka today?
No, Your Honor.
Okay. Is there any other community corrections officer at the Greenwood County Courthouse today?
Not that I'm aware of, Judge.
Okay. So what direction would you give Mr. Likes?
Well, Judge,
Okay. Sheriff Samuels has his hand up. Sheriff?
Since I have a warrant for his arrest in Butler County, I would be willing to transport him over to the Butler County Jail. Somebody could see him today.
Okay. Well,
Okay.
I appreciate that information, Mr. Samuels. Okay, that probably is how the first meeting is going to be handled then, Christie. So thank you for your presence on this meeting. All right. Mr. Likes, you have any questions about what we've done here today in this Greenwood County case?
No, sir, I think it's been explained extremely well, and I'm not considering an appeal because I own every offense you read off, and I'm willing to pay my debt to society.
Okay, I appreciate that, Mr. Likes. You need to be 100% successful on this. I really don't want to see you again on a sentence review. So
I really
good luck.
don't want
Good
to
luck,
see
Mr.
you
Likes.
on Zoom anymore.
Okay, I understand perfectly.
I'd rather see you in the Dillon's parking lot.
Okay,
Judge, he had an ankle monitor on for scram. Are you authorizing that to be removed today?
he can take that off. I'm going to trust Mr. Likes to stick to his word at this point.
Yes, sir, I will.
Okay, good luck over in Butler with whatever you're dealing with there, Mr. Likes.
Yeah, I don't know. Thank you.
All right.
Before we get out of here, do we have another case? The misdemeanor case?
The misdemeanor case here was dismissed pursuant to the plea agreement. The misdemeanor case
In its entirety?
Uh-huh.
Okay, great.
And the misdemeanor case in Elk, there were 2 misdemeanor cases there.
Yes.
One of sentence is for sentencing and one of them is dismissed.
All right.
So,
Hey, George, I'll be talking to you.
Yes, sir. Thank you, Mr. House.
Okay.
I'll
Thank you
double
for your involvement and accommodations of your office, Sheriff Samuels. Always appreciated.
No problem.
All right. If there's nothing further, then the Likes matter will currently be in recess. This meeting may be ended for all at this time.
Thank you, Judge Rick.
Is opposing counsel going to be appearing?
My understanding is he's in an emergency meeting in another county. I've had communication with his office about this issue.
All right. Do we know if Mr. Winchester is aware of the proceeding?
He is. I just spoke with opposing counsel's office about 8 minutes ago, and he was in their office.
Okay, so are we to wait for Mr. Dower?
I don't know. I talked with his assistant Nancy, who said that he was in another county for an emergency motion, and we talked about resolving this, and she said, we'll see what happens. And so then I spoke with her again, and apparently Mr. Dower cannot be here at all because of that other hearing. And I hate doing this, to your honor. I hate these emergency motions, but we're down to the wire at this point.
Is this something you feel can be taken up without Mr. Dower being present?
I do, your honor.
All right, let's go on the record. This is in the District Court of Butler County, Kansas. Case is entitled in the matter of the marriage of Christine Marie Winchester and Clinton Robert Winchester, case number 22 DM 374. Would counsel announce appearance, please?
May it please the court, Christine Winchester appears via Zoom, and by and through counsel Jennifer Goheen, who also appears via Zoom.
All right, we're set at this time on a petitioner's ex parte emergency motion. Ms. Goheen, I know we were just discussing this, but for purposes of the record, if you could outline what brings us here today.
Sure, your honor. When my client originally messaged the respondent in this case, Clinton Winchester, on January 9th, regarding her request to take the minor children out of the country for a cruise to Cozumel, Costa Maya, and Rattan, and she provided the dates and location, stating this was to celebrate the minor children's birthdays and the minor child's graduation in May of 2025. On January 11th, he messaged her and said, right now you are possibly facing numerous contempt charges. I do not feel they need to be leaving the country with you, so no. I filed a motion January 14th, 2025 on my client's behalf to acquire passports for the minor children. We came before this court on January 24th, 2025. Opposing counsel represented that his client agreed to execute the necessary documents for the petitioner to acquire the passports in order for them to participate in the petitioner's planned cruise from March 14th, 2025 to March 23rd. And you ordered that happen. I then filed a notice of submission on January 30th, 2025 by Rule 170. On February 13th, Respondent's counsel provided his consent to that order. Pursuant to that order, my client sent the document entitled Statement of Consent Issuance of a U.S. Passport to a Child via certified mail to the respondent. She advised him via the parenting app that he needed to fill out his portion in front of the notary. She included an extra copy in case there were errors. She included the envelope, I said the document, but she included the envelope that needed to be sent back. She also advised him to read the instructions. On February 19th, my client sent a message stating that he should have received the documents the prior day necessary for the children's passports. She asked to let him know when they were in the mail. On the 20th, the respondent sent her a message, and this is all via the parenting app, and I've included these messages as exhibits. This isn't happening.
Ms. Goheen,
Yes.
I've got Gilliland Green LLC in the waiting room. Is that?
That
Mr.
may
Allen?
be him. I don't know.
Okay.
Yes, that should be them.
It's right here.
Okay.
It's
No, I'm walking back to my office.
okay.
So remind me, when did we send that thing
Here.
back there?
Hello.
Good
Hi,
afternoon.
Judge Crum. Tad just showed up, and if you don't mind waiting, he's going to log in real quick. He didn't know about this hearing apparently. Can you hear me, Your
Miss
Honor?
England.
Yes.
Hello, Ms. Goheen. Okay, so do you mind waiting for Tad, Your Honor, who's logging in now?
Okay, that's fine. I've got another docket I need to tend to at 2:30, so.
Okay. All right. Well, I will wait till he shows up and then I'll log off. How's that?
Thank you.
Yes, thank you.
Miss England used to be my law partner over here until she left me.
Oh.
Let's not get started on that.
I'm still bitter.
And this is my first domestic case, Jennifer.
Well, welcome.
And my last. Welcome. Oh, I see his name. There he is.
There he is.
I'm going to log off. Thank you.
All right, thank you very much.
Bye,
Mr.
JC.
Dower, can you hear me?
Hear me, Judge?
I can hear you. Can you hear me?
I can.
All right. This is an emergency motion that petitioner has filed regarding the passports. Are you up to speed on what's going on, Mr. Dower?
I am literally walking in the door, so I'm kind of getting it from about 3 different angles, but my understanding is my client received the requisite forms last Friday. On Monday morning, he went and got it signed and notarized and returned it to her. He's now being advised that he's required to give her a copy of his driver's license to finish this process. He talked to the passport office. They say, you don't need to give it to her. You just give it to us and we can have it directly, which he's more than willing to do. He's also willing to meet her someplace over there. He just doesn't want to give a copy of his driver's license. And again, I'm not as well prepared as I'd like to be. I think your order was he needed to sign the document, sign the application, which he did. He's done those things. This additional requirement of her having his driver's license is not something that I think was contemplated by the court or the order, certainly not me. But so I'm sorry. I'm just kind of walking in cold.
And I'm unaware of what the issue is, what the necessity for the driver's license. Ms. Goheen, if you can expound upon that, please.
Yes, Your Honor. I looked at the form because we've been going back and forth regarding this. I looked at the form and the form requires you have to attach, and it says it in 2 places on the form, the driver's license, a photo of the driver's license, a photocopy, front and back to the form. And as we all know, the passport office is very particular because the information my client is getting is different from that of Mr. Winchester. So I personally looked at the form, and as an officer of the court, I can tell you that the form says you have to attach these documents to the form. So I will tell you, and if you look at all these messages, my client tells him at least 3 times, she's got to have this form. He refuses to do it. Actually, she gets it back. He hasn't done it. She gets the form back, but he hasn't attached the driver's license photocopy front and back. So my client messages him and says, hey, you have to have this form or this driver's license photocopy front and back. Now, I'll tell you, Judge, these parties were married for 20 years. I have his social security number. I have his birth date. She's got his last 3 driver's license in her possession, knows his social security number, knows his birth date in this particular case. So I don't know what information he's worried about. Yet my client offered, he stated to her, you have to show up. This is what he states on the 20. Well, if I can go back, Judge. What happened is this actually all started beginning of January. Then I filed my motion. They said, we'll execute the documents necessary. I filed the submission. Opposing counsel gives his consent to the order on the 13th. So on the 14th, pursuant to the court order, because we know we have to have your court order signed before anything's going to happen in this case, she sent the document. She advised him of this via the app, told him you have to fill out your portion, sent extra copies, sent the envelope, told him make sure you read those instructions on the first page so that you make sure everything is done right. She sends another message to him on the 19th saying, you should have received these. Will you let me know when you put them in the mail? He says, February 20th, you've had all this time for me to do it. You picked a week that I'm out of town. The judge granted permission to get the passports. I figured that's all you needed was the judge's order. My client responds, when are you going to be back in town? Have you read the court order? February 20th, he says, I'm not certain. It's going to be the following week. He says his next visitation is March 2nd. He's not going to be able to get the kids because he and his family are going on a cruise. And then he asks her to Venmo the fees for getting the documents notarized. My client responds saying, send it back as soon as possible. On the 24th, my client then asks him, did you get the documents notarized? He says, not yet. I didn't get a reply about Venmo for fees. She responds, Clinton, you're hurting the kids. Just please get it done and sent in the mail today. He responds, I'm not paying for your vacation. Venmo me $40 for my fees and gas. My client says, you're not paying for the vacation. I am. It's court ordered that you sign the documents. He says, which I did, didn't say I had to pay the fees and mailing costs.
What a tool. Seriously. I can never wrap my head around why people do this to their children. And here's the thing. All of these messages that the attorney is reading off, those are done in the parenting app. So it's not like, regular text messages where things can be deleted or it can be made to look like someone is saying something that they're not. No. This is all recorded in a court accessible app. And he's acting this way.
My client asked, did you do it in front of the notary? And what fees were incurred as she already paid for the passport? He says there's a mailing fee that's $10.85. My client asked, did you make copies of your driver's license and ask for his Venmo so she can pay him $25 for the notary and this mailing cost? Mm-hmm. Even though she didn't think this was fair, she wanted to do what was best for the kids. She again advised him, make sure you have a front and back copy of your driver's license, the one that you use to show the notary. He advised, you don't care about the kids having time to be with me and have a life with me, and you think your narcissistic guilt trips about this cruise is best for the kids is going to make me care. I could care less. Then he provided his Venmo. My client responded, she sent the money and asked that he get the documents mailed out that day, as well as another reminder to include a copy of his license front and back. On February 25th, my client messages him and says, when did you get this sent out? He did not respond. On the 26th, my client messages the respondent because she now has the documents. Why did you not send a copy of the driver's license front and back? And told him it was necessary and was included on the form, which it is on the front and it is on the back. And it says you have to attach this. He asked her, or she asked him to email it to her, the photocopy of his driver's license. On the same date, she messaged him again saying, you have to submit this clear photocopy of the front and back of the ID that you presented to the notary, and said it's on the back as well. On the 27th of February, the respondent messages the petitioner asking where he could mail a copy of his license, as he did not want her to have his personal information. So this is days after this all started. My client says this has to go with the applications and they all need to go together. The respondent told her to send him the applications and he would send them in, as he did not want her to have his personal information. My client advises him, I don't have time to do this and I need to overnight it by tomorrow. She asked what personal information he thought was on his driver's license that he was concerned about. She advised that she did not care about his personal information, but she needed this for these applications. He responds and says he called the passport office and he could send in his copy of the ID with the applications. And my client had until 2 p.m. that day to drop off the applications at his attorney's office, and he would be there within an hour. He said, I'm leaving town at 4 p.m. and you need to have this here by 2 p.m. and it's your fault you waited till the last minute. My client advises him, I can't take off work early and would not make it to Hutch by 4 p.m. He advised that he could have his attorney email the copy of the license to me, and she'll drop the envelopes to me and our office would seal them out and mail them out. So then I only have a copy of the driver's license. He advised that he would not give his information to the petitioner or to me. I think I put in there the respondent, but or to me as counsel. He falsely alleged she had taken out loans and credit cards in his name without his consent, which was not even part of the pretrial in this case. My client informs him that he failed to follow the court orders. On the 27th, I contact respondent's counsel's office. I say, this is the issue. Here's the correspondence between the two. I'm going to have to file an emergency motion and ask for fees. On the 28th, I get a response from respondent's counsel asking where the documents need to be sent to. And I said, he can email them this directly to the petitioner. Thereafter, I was informed he did not want her to have the information. I believe respondent's counsel's office was trying to assist in getting this done, but the problem is that Mr. Winchester is causing a problem in this particular case. This could be sent to me. And again, I have all of his personal information. This could be sent to me and I could send out the necessary documents, but he's refusing to do that. So then they want us to give all the documents to them. Now, my client's an Andover judge. This needed to be done like yesterday, and we're going back and forth over this craziness to a man that she was married to for 20 years, whose information she has. He has hers, we have his. So I do not understand what the problem is. I don't understand it. This already needed to be done. I am fine if they want to email the driver's license information to me, the photocopy, and then I'll have my client rush over here to get this in the mail so that we can get it done today. I just simply, this is the nonsense we've been dealing with in this case since the beginning. So I'm asking for attorney fees, Judge, of $750 because I had to file this motion. And I want him to be fined $200 for every hour he fails to get this photocopy to me. That may seem harsh, but quite frankly, this isn't about these parties. This is about the kids. This should have been resolved. It's a problem on Mr. Winchester's part to create this problem where he didn't have this problem at the beginning. He only has this problem after certain steps are completed. Then we have another roadblock. He can go on a cruise with his family, but he can't make this happen for the party's minor children. It's insulting to my client. It's infuriating. It's costing fees that she doesn't have in this case. And all she's trying to do is something nice for their children. Thank you, Judge.
Thank you, Ms. Goheen. Mr. Dower?
We said in court on the 24th, we'd sign the document, and we signed the document, and that's what your order says. We returned it. We don't know about this driver's license requirement until I think Monday or Tuesday of this week. And we have offered alternatives for how to get that information to them so as to not give her the driver's license. And, you know, do I hear somewhat counsel saying, sure, she knows his date of birth, she knows his address, the kind of things you'd see on a driver's license. The current driver's license number, I don't know if she knows that. And they can say it's false allegations. My client will tell you, we know she's done it, and we just don't want to have a problem. We're not refusing. We made offers to them to get this information to the passport office. I think we can do it directly to them is what I'm being told. And if that's the case, we'll do that today. The fact that this is even considered an emergency, I mean, I haven't had a chance to look at anything. I was in trial all day yesterday, all day this morning, out of town, just getting back in here, but he has signed the document. He'll get the information to the passport office. I don't know why she waited until last week to send it. I mean, I don't know if this was such a crisis. I would have thought it would have happened earlier, but that's where we are. And he is not refusing. He just doesn't think your order included giving her a copy of his driver's license. I'd ask you not to award fees or sanctions in this matter. He has not willfully refused to comply with the order. He signed it when he got it.
It
And he did it
includes,
in front of
the
a
order
notary.
includes, his client agrees to execute the documents necessary for the petitioner to acquire the passports for the minor children for them to participate in the cruise. So I think that includes any documents necessary to get this done.
Right.
And if I did this, I don't know, a year ago, and I remember sitting in the library, filled out at least 4 different forms that I had to eventually rip apart because I put something in the wrong spot. So I know they're very specific about how they want these. I don't recall what was required regarding the driver's license. But I know we had to provide a driver's license. Of course, we were all there together and it wasn't a mess like this. But if the form requires that he provide a copy of the driver's license, I can't imagine there being any information on there that's going to be used to for nefarious purposes. And if it requires that he provide a copy of that, that needs to be done today, immediately. Is this something the copy of the driver's license gets mailed in along with the rest of the application?
You have to attach the driver's license to the application.
All right.
Well,
Perhaps to, just as to calm Mr. Winchester down, perhaps a copy can be retained at Ms. Goheen's file without a copy of that being provided to Miss Winchester.
You know,
again, I think that's a little, it just needs to get done.
I agree.
He needs to provide that, but if he's got the copies, get those emailed over there immediately. So that was the court's intent. I believe that's involved in executing the documents necessary to get it done.
I'll get a copy of his driver's license.
Front and back.
Yes.
Do you want it to come to me and then
I'll send it to you, Jennifer, and I know you'll do what you're supposed to do with it. I'll do that.
so you want me to just keep it and have her bring the documents here and then
Right.
we'll send it out?
You can shred it afterwards after it gets attached to the copy of the application. I'll just do it that way. Just shred it.
Okay, I'll have her run to my office to bring me the documents so I can have my runner get them out today.
Okay. All right.
I'm gonna order Mr. Winchester pay $500 in fees. I'll hold in abeyance the request for the $200 an hour fee. I just want to make sure this gets done.
I understand, Judge, and I'd ask you to maybe take that under advisement. I mean, they have been going back and forth. She didn't like his suggestions, okay? But he wasn't trying to not get this thing done either. And again, having just walked in here, I could see the exchanges between the two of them going back and forth, trying to figure out how to get it done. I think to assess fees against him at this point in time, I just ask that you take that under advisement. If he doesn't get this thing done here in the next 20 minutes, then certainly you can impose your.
The $500 fees are being ordered. The fact that we had to show up here to do this shows that there's not cooperation on him to get this done.
Yeah. All right.
Thank you,
Thank you.
Judge.
All right, anything else?
No, sir.
No, Your Honor.
All right, we'll be in recess. Thank you.
Thank you.
Thank you, Judge.
Yeah, that dad was being a total butthead. And he knew what he was doing the whole time. And I think his attorney was actually kind of annoyed with him. Like, how do I defend this? You know, they got to think on the fly with that stuff. And yeah, his client was not helping him. Not even a little bit. He was creating a worse situation. So, yeah. I hope you guys enjoyed that. My day shift live. And now I need to get ready for the night shift. I think I found the contemptuous hearing between Jill and Judge Webster that y'all have been talking about, that you've asked me to find. I think I found it. So, I'm going to put that on for tonight so that y'all have it. So if you haven't seen it, you know, just come to tonight and we'll watch it together. I haven't seen it yet. I haven't. So yeah, but I do think I found it. Hopefully. I told you I would, Mama. I'm trying. I'm doing it for you. That would be much appreciated. I haven't seen it, so don't tell me. All right, guys. I love you so much. Thank you for being here. I am very trying. Yes. But you know what? You picked me. Terry Barnes with my big Kentucky hugs. Thank you for coming, honey. It was so good to see you. Yes, thank you. I love you. Maybe get in on the beginning of the show so that you don't have to watch it at 1.5 times. I love you. Well, hopefully it won't be good night yet. Hopefully I can stay awake editing. Oh my goodness. I'm going to try. Arg. My bangs are driving me crazy. Makes it look like I have a receding hairline because it pops up at that one spot. I have to always kind of try to hide it. A little bit. But I love you. Thank you, Nana Laura. All right, guys. Be safe, be well, sleep sweet, and much love.